Greetings, Judge. Will you want, I believe Mr. Chambliss is on the Zoom. Would you want him to commence the argument now?
So let me go ahead and just resume. We are back on the record in the 210th District Court. This is cause number 2020 DCB 3335. Parties have announced ready, if I'm not mistaken. Everybody announced ready. We are scheduled for a summary judgment hearing as well as a final status conference. Summary judgment brought by Ford, defendant Ford Motor Company. If you all are ready,
Your
I
Honor,
as well.
I apologize for interrupting, Your Honor. Maxwell Bayman, I'm appearing on behalf of non-moving defendants, HMV Trucking and Ryan Martin. We have settled our interests, so I'm present for the final status conference. So I just wanted to make my appearance on the record.
Okay, and that's how I, in reviewing the case, I think I had seen that. I thought everything was settled with respect to Mr. Martin and HMV Trucking.
Yes, Your Honor.
Mr. Bayman, so obviously you're welcome to stay, but let's go ahead and get started on the summary judgment.
Good morning, Your Honor. If I may proceed.
You may.
In this action, Ford's moved, and I'll get into the specifics of the accident, sort of the underlying claims, but the Ford's motion in the case is it's a partial summary judgment, traditional and no evidence on three claims: a marketing defect claim, a manufacturing defect claim, and punitive damages. As a point of clarification, plaintiff's response only addressed the punitive damage claim, and I believe they've amended their petition. But it doesn't, the amended petition to me is not clear that it drops the failure to warn, marketing defect claim, or the manufacturing defect claim. So no need to argue those if Mr. Marks intends to drop those claims, and that might be a question for Mr. Marks.
Yes.
Your Honor, Greg Marks here. Yes, we are dropping the marketing defect claim and the manufacturing defect claim. So it is a design defect claim only.
Understood.
Okay.
Thank you. Okay, Mr. Chambliss.
Thank you, Mr. Marks. You know, Judge, however you want to proceed with this, I don't have a PowerPoint, but I do have I kind of jotted down a few an outline, a couple of photographs. It might help as we go through this if I publish that.
Sure. Is the function there, Mr. Marufo, for participants to share their screen? Is that open? I think the default is to not allow.
It's open to one participant to share at a time, Judge.
Okay, Mr. Chambliss, go ahead.
Okay, let me. Okay, let's see. Can you, Your Honor, see my screen? And do you see an accident diagram?
I do.
Okay, then I'll sort of walk through it like this. This lawsuit originates from a 3-vehicle accident, 2 vehicles and a tractor trailer. It occurred back in February of 2019 in Parker County, which is just west of Fort Worth, near Weatherford, Texas, on Interstate 20. And in the eastbound lanes, and I'll just sort of walk through here, this is the interstate headed east. There's a Unit 1 and a Unit 2, Unit 1 being a Chevrolet Cobalt, and then Unit 2 being the 2019 Ford Explorer. And then parked on the side of the road was a tractor trailer. For reasons that are not maybe completely known and perhaps in dispute, the 2 passenger vehicles lost control or left the roadway. But for our purposes, the important part is that Unit 2, the Ford Explorer, went into a counterclockwise rotation and struck the rear end of the parked 18-wheeler. And what was important for our purposes is Ms. Jenkins, who was significantly injured in this crash, was driving the Ford Explorer. And when the vehicle rotated and made contact with the 18-wheeler, the contact was on the passenger sort of rear side of the vehicle. And if I may scroll down, this is an accident scene photograph of the Ford Explorer. Can you see that, Your Honor?
Yes, sorry, I was muted.
And this is the Ford Explorer that this case is about. This was the impact, this significant impact to the sort of rear passenger side of the Ford Explorer. And the photograph below is more of a photo, static photo, if you will, from one of the experts' shops. Now, Ms. Jenkins was the driver of the vehicle. And as the court can see, the impact, which was an enormous impact to this vehicle, was on the passenger side. So inside the vehicle, as Ms. Jenkins' vehicle impacted the tractor trailer, which was parked, her body, the biomechanics of it were such that her body continued to move toward the way the vehicle was rotating. So when it hits the tractor trailer, it stops, she continues to move. At the same time, the vehicle was being crushed inward. So as a result of that, tragically, Ms. Jenkins' head, and Ms. Jenkins was wearing her seatbelt, but Ms. Jenkins' head makes contact with this red circled area, which is, this is the passenger side of the vehicle interior view. This was what we call the B pillar, which is just adjacent to the passenger seat. And this is a side air canopy curtain that had deployed. Just below this, this was the impact Ms. Jenkins made with her head. So from, as the vehicle's crushing in and she's moving rearward, this impact was so violent, her head made contact with the lower part of the B pillar in this vehicle, and she sustained significant injuries. Now, just by way of background, plaintiff's claims, and these are from plaintiff's experts, the reason they believe this vehicle was defective is that Ford, and I'll just sort of skim these, that Ford should have included better padding in this lower B pillar area that I just showed, Your Honor, and then a delayed deployment strategy for a passenger seat mounted side impact airbag. Also, they include an alternative design, which plaintiffs are required to in design defect cases, that would include better padding and a delayed airbag deployment. They allege they were available, practical, and feasible. And then they also claim that it should have included better padding in the delayed airbag strategy mode. And because it didn't have those, it was defective. Now, these are the general claims. There may be some nuances to this. However, the only reason I bring these out to Your Honor is because our issue here today is a partial summary judgment motion on whether Ford was grossly negligent when they designed and produced this vehicle. So these claims that I've identified for Your Honor, these are really not directly at issue. This is what the trial would be about. This is what the evidence would go and a jury would hear as to whether this vehicle was or was not allegedly defective, and then whether it caused these injuries, and whether there was an alternative design that could have prevented it. These are not the issues that are directly at issue here today, and that's why it's important to note, Your Honor. That's why I mentioned them. What our motion is about is a slice, and narrow slice, if you will, of this case, and that's gross negligence. Plaintiff for seeking punitive damages, and as Your Honor probably knows, to establish gross negligence, they have to show an extreme degree of risk. Ford was actually subjectively aware of this risk, and this is the most important for our motion here today, that Ford proceeded with conscious indifference to plaintiff's safety despite knowledge of this risk. As Your Honor knows, punitive damages are only for rare cases. They're essentially quasi-criminal in nature. And so we have a heightened burden of proof in these cases, as Your Honor knows, clearing convincing evidence. But sort of subsumed within these elements are two components. And one is what we call the objective component, and that's this extreme risk that I mentioned, and that's an extreme degree of risk. It has to be something more than just a remote possibility of serious harm. It has to be the likelihood of a serious injury. And I'm not going to spend a lot of time arguing this point. We believe our motion could be granted on this point alone, given that this particular accident is incredibly rare. It's in the 99th percentile of accidents. And it's really one where that well, I'm not going to argue this one today, Judge, because the one where we're focusing on here is a conscious indifference. And to show that, and this is straight from the case law, they would have to show that Ford knew of this extreme risk, but did not care to address it. And that's the important part. And that's, of course, be shown by clear and convincing evidence. And what we have in the case, and we've set this forth in our motion, are some undisputed facts. And those are that Ford was part of a consortium that studied these far side impact crashes, which are rare, and it attempted to identify potential countermeasures to protect the occupants in these far side crashes. Again, far side being where the crash on the far side and you protect occupants on the opposite. So they're automatically rare, but Ford was part of a study to develop and learn about countermeasures. And if you just consider that, Your Honor, that Ford was part of a consortium to study this, that automatically negates the element they must show that Ford didn't care. But Ford not only participated in the consortium, out of that were some countermeasures that were proposed, and two of them were deploying a seatbelt pretensioner and a side curtain airbag, and Ford included both of those in this vehicle. And I believe Your Honor saw in the photograph, the photo of the side curtain airbag, that the pretensioner is another device within the seatbelt itself. And it's in general terms, it's designed to activate just before a crash occurs. It's a pyrotechnic device. It activates and it draws in some slack of a seatbelt. So again, these are measures that Ford employed to protect occupants in far side crashes. There were other countermeasures that were considered, such as a 4-point restraint and airbags on the far side, but Ford did not include those, but for potential harm to, for example, pregnant persons and other sort of negative consequences. But they were considered, but for reasons that we've included in our brief, they were not utilized. Now, importantly, plaintiff's design expert is not aware of any 2019 model year vehicles. This was a 2019 year model vehicle that deployed a passenger seat mounted side impact airbag in a far side crash. And that's their alternative design. Plaintiffs are not aware of any federal state statutory requirements that a vehicle manufacturer be designed to include the deployment of a passenger side seat mounted impact of a airbag on a far side crash. And very importantly, in Your Honor, this 2019 Ford motor vehicle satisfied all of the applicable federal motor vehicle safety standards. And among those are 201U. And without going into all the minutia of that, it's entitled Occupant Protection in Interior Impact, and the standard specifies requirements to afford impact protection for occupants. This vehicle complied with that standard. Plaintiff's response, and Mr. Marks, I'm sure will do an adequate job of arguing that, but I'll just to give a preview, it sort of misses the mark, Your Honor. It talks about other countermeasures that Ford didn't utilize, and like a center stack airbag and a reverse seatbelt that was used, I think, in a Lamborghini at one point. But if Your Honor looks at the brief on that, the only evidence of that is they just asked Ford's experts if they were aware of it, and yeah, they were aware of it. There's no other proof that any of those things were actually considered by any other motor vehicle manufacturers. They're not even in plaintiff's expert reports where it would have made a difference here. But the important part is it's sort of in some ways a red herring as well, because what it does, it shifts focus away from what Ford did do. And the requirement is they have to show that Ford proceeded with conscious indifference, and they can't show that. And then the last argument they had was, well, judge, just defer ruling on the motion. You don't have to do it, and you can wait and take it away at the jury's verdict form stage. And Your Honor, that's problematic for a lot of reasons. When this case is tried, whether punitive damages and gross negligence claim is pending, it is going to affect what evidence will be submitted and possibly admitted. It'll have a drastic effect on the jury instructions. It'll have effect on pretrial filings. They increase dramatically if punitive damages are included, and also in voir dire, Your Honor, if they intend to voir dire the jury on punitive damages and try to exclude jurors for that reason, that would prejudice Ford's case if the claim shouldn't be there. And overall, by waiting and not dismissing punitive damage case and just deferring it to the evidence comes in, it would prejudice the whole case. And that's the risk it gets run in these. I mean, we have partial summary judgment motions for a reason, for claims that just shouldn't move forward. And there's been no evidence, again, setting aside whether the vehicle was defective or not. That's what the trial is going to be about. That's what all this underlying evidence is going to be presented. So just saying, well, I've got an expert who's going to say Ford should have did this, should have done that. That doesn't address what Ford did. And it doesn't show, and it doesn't negate the element of conscious indifference. So the elements are slightly different. It always seems to get argued that, well, they should have done this or this. It gets into the merits of whether Ford was negligent for not doing it. And that's a debate that can be had during the trial. But on this issue, Ford did a substantial amount, complied with all the applicable federal motor vehicle safety standards, and we would ask the court to grant summary judgment on this claim.
Thank you, Mr. Chambliss. Mr. Marks? And Mr. Chambliss, I'll ask, thank you very much.
Thank you. Thank you, Your Honor. Well, as the court knows, even in a partial summary judgment, the court needs to take our evidence as true, giving us every reasonable inference. And basically, the courts, including the Texas Supreme Court, have said if there's more than a scintilla of evidence of gross negligence, then that's a question for the jury. And so we go back to what Mr. Chambliss said. My expert has actually given three alternatives: a center stack airbag, reverse geometry seatbelt, and then utilizing the components that were available in the 2019 Ford Explorer. And a combination, any one of those or a combination of those would have significantly reduced the risk of her head injury. So let's go to the question of punitive damages, because that's what this partial summary judgment is about. And as Mr. Chambliss correctly pointed out, there are two elements. One is an objective standard, i.e., was there a risk? Was there a significant risk? And in my brief, in my response, I've shown the court testimony from Ford's corporate representative where he agreed with the statistics that, number one, side impacts, taking side impacts as a whole, both near and far, account for the most significant injuries in all different crash modes. Frequency-wise, frontal collisions are the most frequent, followed by side impacts, both near side and far side. So they are very frequent, far side and near side. Far side, but far side and near side crashes account for the most significant injuries. Far side accounts for almost half of the significant injuries of all side impact. So, and in my brief, I point out that about 17,000 serious injuries and deaths occur every year in far side crashes in the US alone. So it is a significant injury. The mechanism of injury is well known as well and has been known since the 1990s, the early 90s, according to Mr. Krishnaswamy, who is Ford's corporate rep. He admits that, yes, we know that on the far side impact, the body wants to move towards the impact, even though there's a shoulder belt, because the shoulder belt goes over, they will slip the belt and their torso will rotate over and head towards the other side. And what is the most common point of impact? the opposite side door and the opposite side B pillar. So Mr. Krishnaswamy understood before 2019 that in a far side impact, there was a significant risk of head injury, because i.e. head injury is the #1 injury in a far side crash, and that head injury is most likely going to be caused by contact with the B pillar. So the first objective, there is more than the first element, which is objective evidence of a risk, of a significant risk. I have more than a scintilla of evidence on that. So let's go back to that Ford was aware of the risk, but did not care, because that's the evidence. I mean, that's the second prong, or what is called the subjective element of gross negligence. So here's what we have on that. Ford was aware. There's a thing called countermeasures, and it's things that Ford could put in to reduce or mitigate the risk of injury. For example, seat belts is a countermeasure. Airbags are a countermeasure. And there were 3 countermeasures that were identified as early as 2000, in the early 2000s. One was a center stack airbag, which, by the way, that is a safer alternative design identified by my experts in their depositions. Mr. Chambly said that the expert said that no 2019 vehicle had that. That's not true. GM had center stack airbags specifically for far side crashes to mitigate the excursion in a far side crash. The second is a lap belt pretensioner, because even though you tighten up the shoulder belt part, you can still slip, and they knew that. But if you tighten up the lap belt, then their hips are not going to rotate, and it limits the excursion. Ford specifically designed their lap belt pretensioner that was available in this vehicle not to fire in a far side crash. Not to fire. Another component was reverse geometry seatbelts. Lamborghini had reverse geometry seatbelts in their vehicles. Ford has never put a reverse geometry belt in their front row seats. They put them in the back row seats, but not in the front row seats. So there were 2 alternatives that were in production vehicles that Ford refused to put into their production vehicles: center stack airbags and reverse geometry belts. That evidence alone is sufficient to show that Ford does not care. But there's more evidence. Mr. Krishnaswamy admits that even though they have performance criteria in every other crash mode, and what I mean by performance criteria, they test. And a lot of these tests have crash dummies in, and these crash dummies have to meet certain injury criteria. And so in a frontal crash test, they have performance criteria, and they measure injury values for dummies in certain crashes, frontal crashes. And if they don't meet that, then they go back to the drawing board and redesign it to make sure they can provide protection to their occupants in frontal crashes. Same with near side crashes. They have the exact same thing. They have performance criteria where these individuals, these crash dummies, have to meet certain injury values. Rear impact, even though the federal government doesn't require injury criteria on crash dummies for rear impacts, Ford does have performance criteria for their rear impact tests. Hold on, my mouth's getting dry. Rollovers. They have performance criteria for rollovers. Now, they don't put crash dummies in there and make sure that they meet certain injury values, but they have performance criteria for rollovers. They have nothing for far side crashes, even though they've known since the 1990s that this is one of the most, this is the crash mode that creates one of the most significant risks of injuries. So that shows that they don't care. That's evidence that they don't care. And Mr. Krishnaswamy admits that Ford has designed no specific countermeasures. Let's strike that. Mr. Krishnaswamy admits, and it's part of the evidence that I've submitted, that Ford has done nothing to specifically address the far side risks. So that also shows that Ford does not care. So I have more than a scintilla of evidence to prove gross negligence. And at this stage, it would be the risk that if the court grants the partial summary judgment, there is a potential. I'm not saying the court's going to be wrong on it, but there is a potential for already putting error in this case. The court can wait to see what the evidence is as fully fleshed out. There are 3 other times when the court can decide this. Number 1, at the end of my evidence and decide on a directed verdict. Number 2, on a JNOV.
I'm sorry.
Number
Hold on, Judge. I'm not seeing Judge move. Give me a minute.
I guess I talked too long.